So, what does it actually take to put someone on trial? I mean, really think about that. It's a huge question, and it gets right to the heart of our justice system. An accusation, just the accusation alone, can completely upend a person's life. Today, we're diving into a really powerful legal argument that asks a critical question. Is the bar for even starting a criminal trial high enough to protect people who might be innocent? All right, here's how we're going to break it down. First, we'll look at a pretty recent change in the legal standard. Then, we're going to unpack the problem with one single but super important word. After that, we'll get into a proposal for a much higher bar, see how the old and new ideas stack up side by side, and then we'll tie it all together to see why this whole debate is so incredibly important for justice. Okay, so our story really kicks off with a landmark decision. Back in December 2025, the Supreme Court of India established a new legal precedent, and it fundamentally changed the rules for when a criminal prosecution can even get off the ground. Now, on the surface, this looked like a huge step in the right direction. The court ruled that a trial can't begin unless there's a reasonable prospect of conviction. This got rid of the old, much lower bar, which was just a grave suspicion. So, yeah, definitely a positive move. But, as we're about to see, the argument is that this new standard, well, it still doesn't quite go far enough. And that brings us to the core of the problem. You know, in law, words have immense power. The exact phrasing can be the difference between a just outcome and a terrible injustice. And in this new standard, it all hangs on one little word: prospect. So, what does prospect really mean anyway? Well, at its root, it just means possibility. A reasonable prospect is nothing more than a reasonable possibility. And right there, that's the fundamental flaw. Is a mere possibility, even if it's a reasonable one, really enough to justify putting a person through the absolute ordeal of a criminal trial? The argument here is crystal clear. You can't launch a prosecution based on chances of a conviction, even if you think those chances are high. Justice shouldn't be a roll of the dice. It needs to be built on something much, much more solid than that. And we just can't forget the human cost here. Being put on trial is a massive burden. We're talking financially, emotionally, your reputation, everything. The source calls it a grave detriment. And when the stakes are that high for a person, the standard for starting that whole process has to be exceptionally high to match. It's only fair. So, if reasonable prospect isn't cutting it, what's the alternative? Well, there's a proposal for a new, much more rigorous standard that completely changes the question we should be asking. Now, here is the proposed test, and the wording is absolutely critical. The prosecution has to be of the opinion that the material it has is enough to secure a conviction. Do you see that shift? We're not talking about possibility or chance anymore. We're talking about a firm, confident belief in the adequacy of the evidence. And here's how this would actually play out. It's a two-step process, and it's all about accountability. First, the prosecution has to honestly believe, internally, that their evidence is strong enough to clear the beyond a reasonable doubt hurdle. But it doesn't end there. Step two is the crucial check and balance. The court has to independently look at that material and agree with the prosecution's assessment. Only then could a trial begin. To really let this sink in, let's put the two standards right next to each other. This is where the difference between them becomes incredibly obvious. Okay, look at this. On the left, you have the current standard, all about possibility and chance. It's like a shaky bridge. But on the right, the proposed standard is built on confidence and conclusion. That's a solid foundation. It requires the prosecution to believe their evidence isn't just promising, but that it's enough. It's a huge leap from, we think we might win, to we're confident our evidence proves guilt. Let's just boil this down to its absolute essence. The reasonable prospect test? It's basically a strong maybe. It asks the question, is a conviction possible? The proposed standard, on the other hand, demands a confident yes. It asks a totally different and, frankly, more profound question. Is this material adequate? So let's bring this all home. Why does this seemingly technical legal debate matter so much? Well, it matters because it connects directly to fairness and the very real human cost of our justice system. So what's the big takeaway? Adopting this higher standard would do a few crucial things. It would balance the scales of justice more fairly between the state and the individual. It would be a much stronger shield, protecting people from that grave detriment of a trial based on weak evidence. And it would force the entire system to operate on confidence, not just chance, making sure the start of a trial aligns with its only real goal, proving guilt beyond a reasonable doubt. In the end, it really all comes down to this single powerful idea. A trial should only happen when fairness demands it. And what does fairness demand? It demands that the evidence, right from the very beginning, clearly points to guilt without any reasonable doubt. This is about taking the idea of presumed innocent seriously, not just as a rule in a courtroom, but as a guiding principle from the very first moment. And that leaves us with one final big question to think about. When we weigh the good of society against the rights of one person, what is the true price of putting someone on trial? And is a reasonable possibility really a high enough standard to make someone pay it? Thanks for digging into this with me.